This one here goes out to John Jacobs, who we should all be grateful for, who relayed this information to me. And I'm going to read it to you. I was going to go to bed, and like a little kid before Christmas, staring at a package, I can't go to sleep now. And I made the mistake of peeking at it before I was going to go to bed, and I can't go to bed without reading it, unfortunately. So, here we are. Thanks, John Jacobs. U.S. Poindexter versus Greenhow, 114, U.S. 270, 1884, 5S period CT period 903, decided January 1st of 1884. In error, the Hustings Court of the City of Richmond, State of Virginia, October term 1884. The importance of this case, ladies and gentlemen, is remarkable. And for those of you that wish to follow me along, it's the Poindexter versus Greenhow, 114, U.S. 270, 1884, 5S period, CT period, 903, decided January 1st of 1884. Now, Mr. John Jacobs, beautiful man that he is, relayed this information to me this morning. And it deals with, well, I'm just going to read it. In an action of the detinue for personal property distrained by the defendant for delinquent taxes, in payment of which the plaintiff, which is the man that brought the case back up to the Supreme Court, he's now the plaintiff, had duly tendered coupons cut from bonds issued by the state of Virginia under the Funding Act of March 30th, 1871. What coupons was he cutting, ladies and gentlemen? Could these be the same coupons you're receiving for your electric bill, your gas bill, your water bill, your sewage bill? Think about that for a minute. Held, one, that by the terms of that act and the issue of bonds and coupons in virtue of the same, a contract was made between every coupon holder and the state that such coupons should be receivable at and after maturity for all taxes. Debts, dues, and demands due the state. The right of the coupon holder, under which was to have his coupons received for taxes when offered, and that any act of the state which forbid receipt of those coupons for taxes is a violation of the contract. Whew. Son of a gun. Now you know what I read and why I can't go back to sleep. From here on out, ladies and gentlemen, I have not read this yet, so we're about to get into it. And void as against coupon holders. 2. The faculty of being receivable in payment of taxes was of the essence of the right. It constituted a self-executing remedy in the hands of a taxpayer, and it became thereby the legal duty of every tax collector. What are your American Bar Association members? They're glorified tax collectors. That's what they are. To receive such coupons in payment of taxes upon an equal footing and with equal effect, as though they were money. The coupons in payment of taxes upon an equal footing and with equal effect, as though they were money. ladies and gentlemen. After a tender of such coupons duly made for that purpose, the situation and rights of the taxpayer and coupon holder were precisely what they would have been if he had made a like tender in money. If he had tendered this in silver or gold, because remember, we're back in 1884, then it was equally the same as producing the coupon as a tender of payment. It is well settled by many decisions of this court that for the purposes of effecting proceedings to enforce the payment of taxes, a lawful tender of payment is equivalent to actual payment. Now notice this doesn't say a legal tender of payment. It says a lawful tender of payment is equivalent to actual payment. What's a lawful tender of payment, ladies and gentlemen? Either being sufficient to deprive the collecting officer of all authority for further action, and making every subsequent step illegal and void, because they accosted him against his will after he submitted this coupon, and it should have offset and discharged and made everything right, but they chose to come after this gentleman. And so he made it a point to show them the difference between legal and lawful. The couponing questions are not bills of credit, and these, in the sense of the Constitution, which forbids the state to emit bills of credit, because although issued by the state of Virginia on its credit and made receivable in payment of taxes and negotiable so as to pass from hand to hand by delivery merely, they were not intended to circulate as money between individuals and between government and individuals for the ordinary purpose of society. 5. An action or suit brought by a taxpayer who has duly tendered such coupons in payment of his taxes against the person who, under color of office as tax collector, all right, what are we pointing out here? They're doing things under the color of law, under the color of office, under the color of authority. Ladies and gentlemen, you have a right to action. And acting in the enforcement of a void law passed by the legislator of the state, having refused such tender of coupons, proceeds by seizure and sale of the property of the plaintiff to enforce the collection, 271, of such taxes, is an action or a suit against him personally as a wrongdoer, and not against the state, within the meaning of the 11th Amendment to the Constitution of the United States, number 6. Such a defendant sued as a wrongdoer who seeks to substitute the state in his place or to justify by the authority of the state or to defend on the ground that the state has adopted his act and exonerated him, cannot rest on the bare assertion of his defense, but is bound to establish it, and as, whoops, lost my place here, where was I at? Something again. 5. And acting in the enforcement of a void law passed by legislators of the state, having refused such tender of coupons, proceeds by seizure and sale of the property of the plaintiff to enforce the collection, 271, of such taxes is an action or a suit against him personally as a wrongdoer, and not against the state, within the meaning of the 11th Amendment to the Constitution of the United States. Such a defendant sued as a wrongdoer who seeks to substitute the state in his place, or to justify by the authority of the state, or to defend on the ground that the state has adopted his act and exonerated him cannot rest on the bare assertion of his defense, but is bound to establish it. And as the state is a political corporate body, which can act only through agents and command only by laws, contracts, right? In order to complete his defense, he must produce a valid law of the state, which constitutes his commission as its agent, and a warrant for his act. 7. The Act of General Assembly of Virginia of January 26, 1882, to provide for the more efficient collection of the revenue to support government, maintain the public schools, and to pay interest on the public debt, requiring tax collectors to receive in discharge of the taxes, license taxes, and other dues, gold, silver, United States Treasury notes, national bank currency, and nothing else, and thereby forbidding the receipt of coupons issued under the Act of March 30th, 1871. Now, this is where it gets good. In payment thereof, although it is a legislative act of the government of Virginia, is not a law of the state of Virginia. Do you see the difference, ladies and gentlemen? In payment thereof, although it is a legislative act of the government of Virginia, is not a law of the state of Virginia. You see the difference? Because it impairs the obligation of its contract and is annulled by the Constitution of the United States. 8. The state has passed no such laws, for it cannot. And what it cannot do, in contemplation of law, it has not done. The Constitution of the United States and its own contract, both irrepealable by any act on its part, are the law of Virginia, and that law made in the duty of the defendant to receive the coupons tendered in payment of taxes, and declared every step to enforce the tax thereafter taken to be without warrant of law. So when they were stealing this man's land, they were selling it off for paying his taxes, they're saying that it was without warrant and it was without law, which means this agent and agency was acting in his own personal capacity, no longer enjoying immunity from his office, because he was operating under the color of law, under color of office, under color of authority, and they basically washed their hands of him before he hit the ground. All right? So what I'm trying to articulate to you, it's like having a roofing company and telling people before they hit the ground they're fired. Well, that's exactly what the government does to protect their assets. Okay? ASSEST, right? Assets. And so that's what they do to protect their ass. And therefore a wrong. All right? This strips the defendant of his official character. All right? The defendant is the rogue agent and agency who breached the trust, all while not knowing the law, who probably should have confided in somebody and ascertained a warrant before he went off to sell this man's property, and convicts him of a personal violation of the plaintiff's rights, for which he must personally answer. 9. It is no objection to the remedy in such cases that the statute, the application of which in the particular case is sought to be prevented, is not void on its face, but is complained of only because its operation in the particular instance works a violation of a constitutional right. For the cases are numerous where the tax laws of a state which in their general and proper application are perfectly valid, have been held to become void in particular cases, either as unconstitutional regulations of commerce or as a violation of contracts prohibited by the Constitution, or because in some other way they operate to deprive the party complaining of a right secured to him by the Constitution of the United States. In cases of detinue, the action is purely defensive on the part of the plaintiff. Its object is merely to resist an attempted wrong and to restore the status in quo as it was when the right to be vindicated was invaded. It is analogs to the preventative remedy of injunction in equity when that jurisdiction is invoked, of which frequent examples occur in cases to prevent the illegal taxation of national bank by state authorities. 11. The suit authorized by the Act of the General Assembly of Virginia of January 26, 1882, against the collector of taxes refusing to accept a tender of coupon to recover back the amount paid under protest is no remedy at all for the breach of the contract, which required him to receive the coupon in payment. The taxpayer and coupon holder has a right to say he will not pay the amount a second time, and insisting upon his tender as equivalent to payment. Ladies and gentlemen, I don't realize if you know exactly how powerful the things that I am reading to you are, but I highly suggest that you start to study. The suit authorized by the Act of the General Assembly of Virginia of January 26, 1882, against the collector of taxes refusing to accept a tender of coupon to recover back the amount paid under protest is no remedy at all for the breach of the contract. What contract are they talking about, ladies and gentlemen? The contract that states that the coupon is just as good as tendering a lawful payment. All right? And they're in breach of it when they didn't accept the coupon for the tender of payment and rather went after him for his gold and silver, which required him to receive the coupon in payment. It requires them to receive that coupon as a payment. The taxpayer and coupon holder has a right to say he will not pay the amount a second time. What does that mean? That means as soon as you have tendered that coupon back to the electric company, back to the gas company, back to the wastewater management sewage company, you don't have an obligation to pay them a second time. They threaten to shut off your electricity, your water, your sewer, whatever. They're in breach of the contract because you have lawfully tendered payment and insisting upon his tender as equivalent to payment. To resist the further exaction and treat as a wrongdoer the officer who seizes his property to enforce it, neither can it be considered an adequate remedy in view of the supposed necessity for summary proceedings in matters of revenue and the convenience of the state, which requires that the prompt collection of taxes should not be hindered or embraced. For the revenue system must yield to the contract which the state has lawfully made. Let me do this so I know where I'm at. And the obligation of which by the Constitution it is forbidden to impair. 13. The right to pay in coupons cannot be treated as mere right of set-off, which is part of a remedy merely, when given by the general law, and therefore subject to modifications or repeal. Because the laws which gave it is also a contract, and therefore cannot be changed without mutual consent. 14. The Acts of General Assembly of Virginia of January 26, 1882, and the Amendatory Act of March 13, 1884, are unconstitutional and wholly void because they impair the obligation of the contract of the state with the coupon holder under the Act of March 30th, 1871, and that being the main object of the two acts. The vice which invalidates them pervades them throughout, and in all their provisions. It is not practicable to separate those parts which repeal and abolish the action of trespass and trespass on the case and other particular forms of action as remedies for the taxpayer who has tendered his coupons in payment of taxes. Oh, you just gotta love it. From the main object of the acts, which that prohibition was intended to effectuate, and it follows that the whole of these and similar statutes must be declared to be unconstitutional, null and void. It also follows that these statutes cannot be regarded in the courts of the United States as laws of the state, to be obeyed as rules of decisions in trials at common law, under subsection 721 revised statute, nor as a regulation the practice of those courts under subsection 914 revised statute. Number 15. The present case is not covered by the decision in Attorney versus Greenhow, 107 U.S. 769. The points now involved being expressly reserved in the judgment in this case. Mr. William L. Royal, Mr. Daniel H. Chamberlain, Mr. William B. Hornblower was with him on the brief. Mr. Wagner Swain and Mr. William M. Evarts for the plaintiff in error. Mr. F.S. Blair, Attorney General of the State of Virginia, Mr. Richard T. Merrick, and Mr. Attorney General for defendants in error. Mr. Justice Matthews delivered the opinion of the court. The plaintiff in error, who was also plaintiff below, brought his action in detinue on the 26th day of April, 1883, against Samuel C. Greenhow for the recovery of specific personal property, to wit, one office desk of the value of $30, before a police justice in the city of Richmond, who dismissed the same for want of jurisdiction. An appeal was taken by the plaintiff to the Hustington Court for the city of Richmond, where the facts were found by agreement of parties to be as follows: that the plaintiff was a resident of the city of Richmond in the state of Virginia, that he owed the state of Virginia for taxes on property owned by him in said city for the year of 1882, $12.45, which said taxes were due and leviable for, under the laws of Virginia, on the first day of December 1882, that the defendant Samuel C. Greenhow was the treasurer of the city of Richmond, and as such is charged by law with the duty of collecting taxes due to the state of Virginia. Are you guys noticing the difference in here? They're pointing out Virginia and then the state of Virginia. They're showing you the distinct difference between the two. It's so brutally obvious and right in your face, I don't know how you could ever ignore it. By all residents of said city, that on the 25th day of April 1883, the defendant as such treasurer and collector of taxes made upon the plaintiff's demand for the payment of the taxes due by him to the state as aforesaid. That the plaintiff, when demanded was so made for payment of his taxes, tendered to the defendant in payment thereof 45 cents in lawful money of the United States and coupons issued by the state of Virginia under the provisions of the Act of the General Assembly of the State of March 30th, 1871, entitled An Act to Provide for the Funding and Payment of Public Debt, that said coupons so tendered by plaintiff were all due and past maturity and amounted in the aggregate to $12 and were all cut from bonds issued by the said state of Virginia under the provisions of the said Act of March 30th, 1871, that the said coupons and money so tendered by the plaintiff amounted together to exactly the sum so due the state by the plaintiff for taxes. That the defendant refused to receive the said coupons and money. Now, what do we know from our learnedness? From receiving information that an offering or tendering of payment made is payment made in full when refused, right? That's maximum of law, okay? A payment refused liberates the debtor. So tendered in payment of the plaintiff's taxes that the defendant after said tender was made, as he deemed himself required to do by the acts of Assembly of Virginia, entered the plaintiff's place of business in said city, and levied upon and took possession of the desk, the property of the plaintiff now sued for the purpose of selling the same to pay the taxes due from him, and that said desk is of the value of $30 and still remains in possession of the defendant for the purpose aforesaid, he having refused to return the same to the plaintiff on demand. The Hustings court was of the opinion that the police justice erred in deciding that he had no jurisdiction and that the issue in the action might have been tried by him and that it should be tried by the court on the appeal. But it was also of the opinion that in tendering to the defendant, as part of the tender in payment of the plaintiff's taxes, the coupons mentioned and described, the plaintiff did not tender what the law required, nor what the defendant was, as treasurer, obliged to or should have received in payment of the plaintiff's taxes. Under the provisions of the Act of the General Assembly of Virginia, approved January 26, 1882, entitled An Act to Provide for the More Efficient Collection of the Revenue to Support Government, Maintain the Public Schools, and to pay interest on the public debt, that the plaintiff's remedy for the failure of the defendant as treasurer to receive coupons and payment of taxes was to be found in the provisions of said Act of January 26, 1882, and that, therefore, the defendant does not unlawfully or wrongfully detain the plaintiff's property levied on by the defendant as treasurer of the city of Richmond for the plaintiff's taxes, and judgment was accordingly rendered for the defendant. It appears from the record that there was drawn in question the validity of said Act of the General Assembly of Virginia, approved January 26, 1882, and of the 18th section of the Act of the General Assembly of the State of Virginia, approved April 1st, 1879, which authorized the collection of delinquent taxes by distraint of personal property upon the ground that these acts are repugnant to Section 10 of Article 1 of the Constitution of the United States, which declares that no state shall pass any law impairing the obligation of contracts. The judgment of the court being in favor of the validity of said acts and against the rights claimed by the plaintiff under the Constitution of the United States, the hustings court is the highest court of the state to which the said cause could be taken. The Act of January 26, 1882, the validity of which is thus questioned, is as follows. Be it enacted by the General Assembly of the State of Virginia, the several tax collectors of this Commonwealth shall receive, in discharge of the taxes, license taxes, and other dues, gold, silver, United States Treasury notes, national bank currency, and nothing else, provided that in all cases in which an officer charged by law with the collection of the revenue due to the state shall take any steps for the collection of the same, claimed to be due from any citizen or taxpayer, such person against whom such steps is taken, if he conceives the same to be unjust or illegal or against any statute or to be unconstitutional, may pay the same under protest, and under such payment the officer collecting the same shall pay such revenue into the state treasury, giving notice at the time of such payment to the treasurer that the same was paid under protest. The person so paying such revenue may, at any time, within 30 days after making such payment, and not longer thereafter, sue the said officer so collecting such revenue in the court having jurisdiction of the parties and the amounts. If it be determined that the same was wrongfully collected, for any reason going to the merits of the same, then the court trying the case may certify of record that the same was wrongfully paid and ought to be refunded, and thereupon the auditor of public accounts shall issue his proper warrant for the same. It tells you what a warrant is, doesn't it? A warrant's a check. It's a payment, which shall be paid in preference to other claims on the treasury, except such as have priority by constitutional requirements. There shall be no other remedy in any case of the collection of revenue, or the attempt to collect revenues illegally, or the attempt to collect revenues in funds only receivable by said officers under this law, the same being other and different funds than the taxpayer may tender or claim the right to pay, than such as are herein provided, and no writ for the prevention of any revenue claim, or to hinder or delay the collection or of the same, shall in any wise issue either injunction, supersedis, mandamus, prohibition on any other writ or process whatever. But in all cases, if for any reason any person shall claim that the revenue so collected of him was wrongfully or illegally collected, the remedy for such person shall be as above provided, and in no other manner. In all such cases, if the court certify of record that the officer defendant acted in good faith and diligently defended the action, the necessary cost incurred by him shall be taxed to and paid by the state, as in criminal cases. The Commonwealth attorney for the county or corporation in which suit is brought shall appear and represent the defense. In every case where judgment is rendered for the defendant, a fee of $5 shall be taxed in favor of said attorney and against the plaintiff. And whenever the court shall refuse to certify the good faith and diligence of the officer defending the case, a like fee of $5 shall be taxed against said officer. Any officer charged with the collection of revenue who shall receive payment thereof in anything other than that herein be before provided shall be deemed guilty of a misdemeanor and fined not less than $100 nor more than $500 in the discretion of the court, but nothing herein contained. shall be construed to subject any officer of the state to any suit other than as hereinbefore provided, for any refusal of his part to accept in payment of revenue due the state any kind of description of funds, security, or paper not authorized by this act. 2. This act shall be in force from and after the first day of December, 1882. Subsection 18 of the Act of April 1st, 1879, Acts of 1878 through 79, page 318, so far as material is, that it shall be the duty of the treasurer after the first day of December to call upon each person chargeable with taxes and levies, who has not paid the same prior to that time, or upon the agent of such person resident within the county or corporation, and upon failure or refusal of such person or agent to pay the same, he shall proceed to collect by distress or otherwise goods and chattels, not cattles, chattels, distrained by an officer by provisions of other statutes then in force, where required, to be sold at public sale after due notice, as prescribed. The Act of January 26, 1882, as amended by an act which was passed and took effect March 13, 1884, by the addition of the following section, subsection 2. Whenever any papers purporting to be coupons cut from bonds of this state shall be tendered to the collecting officers in payment of any taxes due to the state by any part desiring to bring a suit under this statute, it shall be the duty of the collecting officer to place the coupons so tendered in an envelope, to seal the said envelope, write his name across the seal thereof, endorse it with the number of the coupons enclosed, and return it to the taxpayer upon the trial of any proceeding under this act. The said coupons enclosed in this said envelope, so sealed and endorsed, must be produced in evidence to prove the tender. If the court shall certify that the money paid under protest ought to be refunded, the said coupons shall be delivered to the auditor of public accounts to be canceled simultaneously with the issue of his warrant. Subsection 3. No action of trespass or trespass on the case shall be brought or maintained against any collecting officer for levying upon the property of any taxpayer who may have tendered in payment, in whole or in part, any coupon or paper purporting to be a coupon cut from bonds of this state for such taxes, and who shall refuse to pay his taxes in gold, silver, United States Treasury notes, or national bank notes. The suit contemplated by this act shall be commenced by a petition filed at Rules, upon which a summons shall be issued to the collecting officer, and the said suit shall be regularly matured like other actions at law, and the coupons tendered shall be filed with said petition. The contract which the plaintiff in error alleges has been violated is with the state of Virginia and is contained in the Act of March 30th, 1871, known as the Funding Act, entitled An Act to Provide for the Funding and Payment of the Public Debt, and in the bonds and coupons issued under its authority, it's provided for the funding of 2/3 of the existing state debt and of 2/3 of the interest occurred thereon to July 1st, 1871, in new 6% bonds to run 34 years. The bonds, and it's telling you, your bonds are going to run 34 years. It's laying out the schematics of how your negotiable instruments work, how your private bills of exchanges work. Ladies and gentlemen, I can't explain to you how important this case is, and I'm only able to recognize it due to the extensive years of research that I have done. The bonds, coupons, or registered payable to order or bearer. Okay, so when they're payable to, it's a what is it? Negotiable instrument, obviously, but it's payable to is a direct pay. But when it's ordered to pay to the bearer, it's a holder in due course situation. And the coupons to bearer, and declared that the coupons should be payable semi-annually and be receivable at and after maturity for all taxes, debts, dues, and demands due the state. Okay, so debts, taxes, dues. All right, this is electricity, water, sewage, in today's date and age. In 1871, I highly doubt they had any of that. At least not that I've noticed in history. And that this should be expressed on their face. For the remaining 1/3, certificates were to be issued to the creditors to the hold as claim against the state of West Virginia. Okay? Oh, now we're West Virginia. That being assumed as her just proportion of the entire debt. Under this act, it was said by this court in Hartman versus Greenhow, 102 U.S. 672, 679, a large number of the creditors of the state holding bonds amounting, including interest thereon, to about $30 million surrendered them and took new bonds with interest coupons annexed for 2/3 of their amount and certificates for the balance. A contract was thus consummated between the state and the holders of the new bonds and the holders of the coupons, from the obligation of which she could not, without their consent, release herself by any subsequent legislation. She thus bound herself not only to pay the bonds when they became due, but to receive the interest coupons from the bearer at and after their maturity to their full amount for any taxes or dues by him to the state. This receivability of the coupons for such taxes and dues was written on the face and accompanied them into whatever hands they passed. It constituted the chief value and was the main consideration offered to the holders of the old bonds to surrender them and accept new bonds for 2/3 of their amount. The same view had been taken by the Supreme Court of Appeals of Virginia in the case of Antony versus Wright, 22 Gratana, 833, Wise versus Rogers, 24 Gratana, 169, and Clark versus Tyler, 30 Gratana, 134. In the last of which cases it was declared to be the settled law of the state, it was repeated by this court in Antony versus Greenhow, 107 U.S. 769, where it was said, page 775, the right of a coupon holder is to have his coupon received for taxes when offered. Page 771, any act of the state which forbids the receipt of these coupons for taxes is a violation of the contract and void as against coupon holder. Upon these propositions, there was an entire agreement between the majority and minority of the courts in that case. The nature and value of this contract right to the coupon holder deserve to be further explained. It was evidently a part of the consideration on which the creditors of the state were induced to accept, under the act of the March 30th, 1871, from the state of Virginia, new obligations for 2/3 of their claim in exchange for their surrender of the obligation of the original bond. The later dependent for their payment as to both principles and interest upon the continued good faith of the state in making, from time to time, necessary appropriations out of the public treasury to meet its recurring liabilities by positive legislation to that effect. In cases of default, there was no remedy by legal process. The state itself could not be sued. Its bare promise to pay had no sanction but the public sense of duty to the public creditors. The only security for their performance was the public faith. All right, this is a faith-based system, ladies and gentlemen. You must be spiritual. You must get with it. You must know who you are to understand how you can achieve a higher quality of life with an ascension of the mind. But immediately on the passage of the Act of March 30th, 1871, and thereafter, occasions or continued default in the payment of interest on the bonds issued in pursuance of its provisions by reasons of failure to provide by law necessary appropriations for its payment was met, if not obviated, by a self-executing remedy lodged by the law in the hands of the creditor himself. For from that time it became the legal duty of every tax collector to receive coupons from these bonds offered for that purpose by taxpayers in payment of taxes upon an equal footing, at an equal value, and with equal effect, as though they were gold or silver or legal tender treasury notes. They were by that act reduced, in effect, into money, and, as between the state and its taxpayers, were a legal tender as money, and being not only a law, but a contract, it became, by force of the Constitution of the United States, irrepealable, and therefore is today what it was when first enacted, an unchangeable law of Virginia. After a tender of such coupons by a taxpayer in payment of taxes and a refusal by a tax collector to receive them, the situation and rights of the taxpayer and coupon holder were previously what they would have been if he had made a like tender in gold coin and it had been refused. What they would be, we shall have occasion presently to inquire. In the meantime, it is clear that the contract obligation embodied in the equality imparted by the law to these coupons of being receivable in payment of taxes is a distinct collateral and real security, placed in the hands of the creditor, intended to enable him to collect them without process of law, as long as the annual tax of the state are sufficient in amount to absorb all coupons that are overdue and unpaid. A certain market is created for them, which will maintain them at or near their par value in the hands. Let me highlight this so I know where I'm going. In the hands of the taxpayer who buys them for tender. They are particularly no longer chosen action, but equal in value and quality to money, and equivalent to receipts for taxes already paid. Now, something I want to point out to you here, equivalent to receipts? Isn't it interesting that every time you go into a store and you buy something, they're always asking you, would you like your receipt? Sure you don't want your receipt? Sir, would you like your receipt? Hey, buddy. Would you like your receipt? And everybody goes, no. Now, why are you throwing your receipts away? Because they're money, ladies and gentlemen. Let me read this to you again. They are particularly no longer chosen action, but equal in value and quality to money and equivalent to receipts. Are receipts money, ladies and gentlemen? Can you convert receipts and bring it back to the source issuer? Yes, you can, for taxes already paid. At the time of the passage of the Act of March 30th, 1871, there existed a remedy by mandamus. In case a tax collector refused to receive the coupons issued under the Act, tender in payment of taxes, to compel him specifically to do so. The cases of Hartman versus Greenhow, 102 U.S. 672, was one in which that relief was administered, and in Antoni versus Greenhow, 107 U.S. 769, it is stated to have been the settled practice of the Supreme Court of Appeals of Virginia to entertain suits for similar relief. By an act of January 14, 1882, the General Assembly of the state of that state modified the proceedings in mandamus in such cases so as to require the taxpayer first to pay his taxes in money, and then the coupons tendered having, in another proceeding, been determined to be genuine. He was entitled to the judgment upon the mandamus, requiring them to be received in payment of the taxes and the money previously paid refunded. The validity of this act became the question in Antoni versus Greenhow, UBI Supra, and it was affirmed on the ground that for the purpose of specifically enforcing the right to have the coupons received in payment of taxes, the new remedy was substantially equivalent to the old one. The court were not willing to decide that it was a suit against the state in which the mode of proceedings could be modified or the remedy taken away altogether at the pleasure of the state, and it affirmed that the right of the coupon holder to have his coupon received for taxes when offered. The question here, said the court, is not as to the right, but as to the remedy the holder has for the enforcement when denied. The question, said the Chief Justice delivering the opinion of the court, we are now to consider is not whether, if the coupon tendered is in fact genuine and such as ought, under the contract, to be received, and the tender is kept good, the treasurer can proceed to collect the tax by distraint or such other process as the laws allow, without making himself personally responsible for any trespass he may commit. But whether the Act of 1882 violates any implied obligation of the state in respect to the remedies that may be employed for the enforcement of its contract, if the collector refuses to take the coupon, that was the case in which it ought. That was a case in which it was sought by mandamus specifically to enforce the contract of the state, which the coupon holder, by compelling by affirmative action and process of law, the collector actually to receive the coupons tender in satisfaction of taxes, it left unaffected the right of the coupon holder and taxpayer, after his tender had been unlawfully refused, to stand upon his contract and the law in defense of his rights, both of person and property, against all unlawful assault and seizures. In the former, he was an actor seeking affirmative relief to compel the specific performance of the contract. In the latter, he is the defendant, passively resting on his rights. Hold on a second. Gonna scroll up. And resisting only demands and exactions sought to be enforced against him in the denial of them. He has himself, in all things, performed the contract on his part and obeyed the law, and simply insist that if more is illegal, exacted, and taken from him, he shall have the remedy which the law gives to every other citizen, not himself in default against the wrongdoer, who, under color of law, but without law, disturbs or disposes him. As we have seen, the coupon holder whose tender of genuine coupons is in payment of taxes has been refused, stands upon the same footing in this respect as though he had tendered gold coin in similar circumstances, and with like result. The question next in order is whether he has any, and if any, what remedy for the recovery of the property disdained to pay the same tax which he has thus already offered and attempted to pay in money or its equivalent. Okay, money or its equivalent, ladies and gentlemen. The system hasn't changed at all, except for we don't have gold and silver anymore. All we have is coupons, credit and debt on ledgers. That's it. That's all we got. Bookkeeping entries, all right? Ladies and gentlemen, this is so important. It is well settled by many decisions of this court that, for the purpose of effecting proceeding to enforce the payment of taxes, a lawful tender of payment is equivalent to actual payment, either being sufficient to deprive the collecting officer of all authority for further action and making every subsequent step illegal and void. In Woodruff versus Trapanel, 10 Howell 190, 208. It was held that the tender of the notes of the Bank of the State of Arkansas by law and a contract with the note holders made receivable in payment of the public dues to the state was equivalent to payment in extinguishing the judgment in satisfaction of which they were offered. The court said, the law of tender which avoids future interest and cost has no application in this case. The right to make payment to the state in this paper arises out of the continuing contract. It's all contract, ladies and gentlemen. It's all contract. It is all contract, which is limited in time by the circulation of those notes to be received. They may be offered in payment of debt due to the state in its own right, before or after judgment, and without regard to the cause of indebtment. In the case of United States versus Lee 106 U.S. 196, it was held that a certificate of a sale of land for tax made by commissioners, which by law was impeachable by proof that the taxes had been paid previous to sale, was rendered void by proof that the commissioner had refused to receive the taxes. Offering and tendering of payment made and refused is payment made in full. Without proof of an actual tender where the commissioner had waived it by a previous notice that they would not accept it, in the opinion of the court, it is said, page 200, this court has in a series of cases established the proposition that where the commissioner refused to receive such taxes, that their action in thus preventing payment was the equivalent of payment in its effect upon the certificate of sale. Citing Bennett versus Hunter, 9 Wall, 326, Tacey versus Irwin, 18 Wall, 549, Atwood versus Weems, 99 U.S. 183, and Hills versus Exchange Bank, 105 U.S. 319. The case then of the plaintiff below is reduced to this. He had paid the taxes demanded of him by a lawful tender. The defendant had no authority of law thereafter to attempt to enforce other payments by seizing his property. In doing so, he ceased to be an officer of the law. When he breached his oath of office, he's no longer an officer of the law. What happens? He assumes personal liability, ladies and gentlemen. That's what that's telling you. And became a private wrongdoer. Well, I'll be a son of a bitch. Private wrongdoer right there. I'm a man, you're a man. What are you doing trying to tell another man what to do? Are you a man? I'm a man. What are you trying to do telling another man what to do? Well, I'm acting under the color of law. Well, you can kiss my ass with the color of law thing. I'm a man, you're a man. Why are you trying to tell another man what to do? See? Because now you're taking him from being a officer of the law to a private wrongdoer, aren't we? Absent a crime, absent a victim, no injury, no corpus delicti, no mens rea, no malium in se, no malium prohibitum, no affiant stating harm, injury, damage, or loss. The officer accosting you is a private frickin' wrongdoer. Period. End of discussion. Moving on. It is the simple case in which the defendant, a natural private person, has unlawfully, with force and arms, now they're bringing in weapons of war, aren't they? Seized, taken, and detained the personal property of another in their private capacity as a wrongdoer. They are seizing your stuff with weapons of war, okay, unlawfully. Over here we see unlawfully as a private person. The badge doesn't mean a damn thing once they breach the contract, ladies and gentlemen. It means jack diddly. Because if you're going to uphold the law, you have to be a man of a great integrity. You have to live by the book to enforce the damn book. All right? Then an action of detinue will lie in such a case, according to the law of Virginia, has not been questioned. The right of recovery would seem to be complete, unless this case can be met and overthrown on some of the grounds maintained in argument by counsel for defendant in error. These we proceed now to examine in their order. It is objected, in the first place, that the law and contract, okay, contract creates the law, equity follows the law. So contract creates this right here, law, all right? By which the equity, there we are. I haven't even read this before. Oh, no, that's this quality. By which the quality of being receivable in payment of taxes to the state is imputed to the coupons, is itself in violation of the clause of the Constitution of the United States, Article 1, Section 10, which declares that no state shall emit bills of credit and is therefore void. The coupons in question are in the ordinary form, and one of them reads as follows. The coupon in questions are in the ordinary form and reads as follows. Receivable at and after maturity for all taxes, debts, and demands due the state. The Commonwealth of Virginia will pay the bearer $30 interest due January 1st, 1884 on bond number 2731, coupon number 20, GEO period RYE treasurer. It is contended that this is a bill of credit in the sense of the Constitution, because being receivable in payment of a debt of debts due the state and negotiable by delivery merely, it was intended to pass from hand to hand and circulate as money. All right. That's all the further I'm getting into that. You guys need to go look this up. What an incredible, absolutely incredible document. Supreme Court case. And let me get up to the top here. And John Jacobs. Thank you, brother. Poindexter versus Greenhouse. 114 U.S. 270, 1884, 5 S period, CT period, 903, decided January 1st, January 1st, 1884. Go look it up. Go review the case. Everybody should read this at least 10 times. I'm tired. I'm not going to go any further into this. It explains private bills of exchange. It explains your coupons that you're receiving today for your electric, wastewater, sewage, and gas. It explains so much. thank you, John. Thank you, John Jacobs. Appreciate you greatly, buddy. And with that, I'm going to let you guys go. Thank you for joining me. You guys really need to go read this. I'll post it on my Facebook wall, too. I'll try to post it on my Facebook wall. See what I can do.